I'm sorry?
I was just reminding you to use the mic.
Okay.
All right, everybody, thank you for your patience. I'm going to call the meeting to order right now, and good morning. I am the chair, Kathy Lewis, today, and this is the Board of Appeals, June 12th, 2026 meeting, being held both in person at the Kona, or at the West Hawaii Civic Center, and as well as virtually on the Zoom platform. I'd just like to go over a few of the online protocols for when we have a Zoom attendance as we do today for the participants. So all cameras should be turned on at all times during the hearings and arguments. One person should speak at a time with no side conversations. Can you please mute your device when you're not speaking to improve the audio quality for all, especially if you've got a noisy background? If you would please try to remember, I'm not good at it myself, but raise your hand, wait for recognition by the chair, me, before speaking to ensure we make a clean and clear record. Prior to speaking, please state your name so that all the parties know who is speaking. Please try to speak slowly, clearly, and close to your microphone. And if you can, limit distractions such as turning off mobile phones and other sound emitting devices. And as a general a reminder to all of us board members, please state your name before speaking throughout our hearing today. And that's one that I find very difficult to do. I'm going to introduce I'd like to have the board members introduce themselves. And as mentioned, I'm Chair Kathy Lewis, and we'll start with you, John, if you'd be so kind.
Good morning, my name is John Kimura. I'm a board member.
Scott, that would shoot over.
Board member Scott Martin.
Vice Chair Rachel Abel.
And on Zoom we have.
Hi, I'm Macy Wilson.
All right, thank you, Macy. Macy's our newest board member here tonight, and so or today. She will be from Zoom. All right. I'd also like to present our Deputy Corporation Counsel, Sylvia Wan. She's our attorney. And Bethany Morrison over there, who is what is your official title, Bethany? Okay, board staff, and temporarily helping us in the back is Kim Tanaka. All right, at this point, we typically take statements from the public for anybody that wants to speak on items on the agenda. Public testifiers can testify now or prior to the agenda item they want to testify on. We'll keep time with that, with everyone getting 3 minutes. But my understanding and Bethany's, we have no such speakers today, so we'll move right along.
No public testifiers, Chair.
Okay, thank you for that, Bethany. All right, so we'll move on then to old business, and we're going to call the first matter, which is 1250 Oceanside LLC, and that is case number PL-BOA-2024-000104. What we've got to look at today are proposed amended findings of fact, conclusions of law, decision, and order. This is pursuant to a judgment on appeal I've got to just say all of this for the record, folks. Judgment on the appeal in 3 CCV-25-00000025 regarding an appeal of planning director's declaratory ruling, docket number 24-0001, dated April 29th, 2024. This was in response to C&J Coupe Family LP petition for declaratory ruling. That was number PL-INT-2024-007028. Dated February 7th, 2024, and supplement to petition for declaratory ruling dated March 27th, 2024. Regarding the dedication of Mauka Halaki'i Extension, Makai Halaki'i Extension and Connector Road to the county, and a request of public hearing or for public hearing. Location Kealakekua, South Kona, TMK paren 3, close paren, 8-1-004:070 and 8-1-030:055. Phew. Okay, Bethany, are there any public testifiers on this agenda item?
No public testifiers, Chair.
All right, thank you. All right, so we are here today as a board to adopt a form of the amended findings of fact, conclusions of law, decision, and order. Has everybody on the board had a chance to review the amended findings of fact, conclusions of law, decision, and order in this matter?
Yes.
And everybody said, all right. And has everybody also read the proposed amended order submitted by Board's Counsel, Sylvia Wan, with the parties' comments and objections and as well as the parties' comments and objections, and Board Counsel submitted suggested edits to her proposed amended order? Everybody? All right. All right, so then we're going to start with the motion so that we can kick off discussions. So the motion at this point would be to approve the proposed amended findings of fact, conclusions, law, decision, and order as stated, or with any amendments you might want to make, whoever makes the motion.
I make a motion that we accept the findings of fact, conclusions of law, decision, and order for 2050 Oceanside PL-BOA-2024-000-104. Excuse me, 104 or 105?
104.
Okay, and just to clarify, Scott, that will be the proposed amended findings.
Yes, the proposed.
As stated in the document.
Correct.
Okay, can I get a second on that?
John Kimura, I second.
Thank you, John. All right, discussion now. Anybody have any discussion on that? All right, well, go ahead.
As counsel, I will note that I did also provide to the board a suggested red line based on the comments and suggestions from the parties. I will just note for the record that at this point, the motion is accepting my first proposal that was set before the board today and does not include those red line edits. So I just want to make the board aware of that at this point, and that's okay. That is the board's kuleana if they want to not adopt the red line edits that I had suggested, and that's fine. I just want to make sure that the board is clear on that.
John, do you want to amend your motion then? I mean, Scott, I'm sorry, Scott. In other words, is your
Yeah,
motion?
my motion is to accept the red line version.
Okay, so with that clarification, I'll take a second on that. Very particular. No. Yeah, John?
Yes.
Thank you. All right, so now we know we're looking at the entirety with its red lines, which includes some additions and deletions. Any discussion on that then? All right, I have a couple of typographical errors I'd like to mention, and I guess if we find them to be acceptable, maybe John would amend his motion to accept them with that. We'll see. All right, on the second page, okay, which this is 104 or 105? This is 104, correct? Yeah.
Yeah.
On the second page, on the last paragraph before findings of fact, there needs to be the word "and" after the first phrase. So I'll say those findings of fact and conclusions of law, blah, blah, blah. Okay, that's one of them.
I'm sorry, I need a little more time to just find so I can take notations
sure.
while you do this. I'm sorry, page number
So
2.
it's
you
page
said?
number 2, the paragraph right before findings of fact,
Okay, thank you.
in the very first sentence needs the "and."
Thank you. So noted.
Okay. On page 4, number 11, the new number 11. 1, 2, 3, 4 lines down on that. The rule states that declaratory orders may be issued instead of can be issued. I'm going to skip something. Yeah, okay. At the top of page 6, the very first line, it says director did not answer specific questions or provides additional information. So it should be provide. So he did not answer or provide. Just getting those singulars and plurals to match up. And the last one is on page 8, the new number 13. Right now, it's the part I want to, with the typo says the planning director in issuing the order did not clearly err, was not arbitrary, capricious, or did not abuse his discretion. Oh, no, that's fine. Or is it? Oh, no, I'm sorry. It says in issuing his order twice. On number 13, it says concluded that in issuing his order, the planning director in issuing his order. So get rid of the second in issuing his order. And that's it. Those are my suggested changes. So it's my understanding in order to vote on that, we would either amend.
I'd like to amend
Yeah.
my recommendation to include the changes that you just noted.
Okay, so the motion has been amended. I will.
Well, no, so motion to amend his motion. We
Right,
need
a
a second.
second. Yeah, that's what I was looking for. Yeah, no, that's okay. Gonna,
Yeah, right. I second John Kimura.
all right. John has seconded it, and so now discussion
So this would be discussion on the proposed
on the
amendments.
whole.
And in order to help facilitate this discussion, I have written in pen an additional red line if the board wants to physically see what Chair Lewis had made as far as her suggested edits. Would you like to see? Okay.
Does anybody need more time with the edits or anything? All right, any discussion? Okay, then we'll take a roll call vote if you would, Bethany,
On the motion to amend?
Yes.
Yeah.
as amended.
So first we're doing the motion to amend and then we'll do the original motion, right?
That is correct.
Yeah, okay. On the motion to amend the original motion to accept the changes from Chair Lewis, Board Member Scott Martin,
Yes.
Board Member John Kimura,
Yes.
Board Member Rachel Abel,
Aye.
Board Member Macy Wilson,
Yes.
and Chair Kathy Lewis.
Aye.
Okay, that motion has been amended.
Okay,
And so now we're back to discussion from the original motion as amended.
okay. So do we have any discussion on at this point? I'm thinking not. All right, then we'll once again take a roll call.
Okay, on the motion to accept the red line, proposed amended findings of fact, conclusions of law, decisions and order with the amendments already accepted. Board Member Scott Martin,
Yes.
Board Member John Kimura,
Yes.
Board Member Rachel Abel,
Aye.
Board Member Macy Wilson,
Yes.
and Chair Kathy Lewis.
Aye.
Chair, you have unanimous.
Thank you, Bethany. All right. Now we're going to do it again for the second order, and I have to go through that long litany. So bear with me, everybody. All right.
And just for we move on, just for clarity of record, they were adopted. Unanimous vote. The board has since adopted the form of its order. Thank you.
Okay, thanks. All right, so we move on to matter number 2 then, which is 1250 Oceanside LLC, PL-BOA-2024-000105. Proposed amended findings of fact, conclusions of law, decision and order pursuant to judgment on Appeal 3 CCV-25-00000028 regarding an appeal of planning director declaratory ruling, docket number 24-0002, dated April 29, 2024, in response to 1250 Oceanside LLC petition for declaratory ruling, PL-INT-2024-007-009, so that was 007-099, dated February 28th, 2024, regarding planning director not ruling upon certain requests and related to the dedication of Mauka Halekiki Extension, Makai Halekiki Extension, and Connector Road. Location, Kealakekua, South Kona, TMK, :3 paren 3, 8-1-004, :070, and 8-1-030, :055. Bethany, are there any public testifiers on this agenda item?
No public testifiers, Chair.
Thank you. All right, then. Once again, we're here to adopt the form of the amended findings of fact, conclusions of law, decision, and order. Has everybody had a chance to read all of the submitted items that we discussed in the last one? Board members, everybody had a chance to review over at home there? Okay. All right.
Kupchak has a hand raised for whatever.
Yes, Mr. Kupchak.
I'd like to recognize in the record the fact that our clients, Charles, Joan, and Matthew Coupe of C&J Coupe Family Limited Partnership are in attendance. Those are the only comments. I wanted the record to reflect that. I think they're in the second row on your left.
Right, we're familiar with them. Thank you. All right.
And thank you, Mr. Kupchak. Yes, we did acknowledge, waved hi to them. They are present. Thank you for both matters, in fact.
Thank you.
That's right. Okay. So I will once again then entertain a very carefully worded motion. To kick things off. It's okay if it wasn't that carefully, but we can always change it. I didn't mean to. We just want to note whether you're moving to adopt it as it originally was written or with the red line. That's the only.
Make a motion that we accept the findings of fact and conclusions of law and decision and order on PL-BOA 204-000-105, 2050 Oceanside LLC.
With the red line?
With the red lines or?
Yes, with the red lines. Thank you.
Okay. All right. Anybody second that?
I'll second that, John Kimura, board member.
Thank you, John. Discussion. All right, hearing no discussion, I have this very similar typos. We'll go over them as quickly as I can. There aren't as many for some reason. On page 5, new number 14, or no, new number 13, on the very last line, petition should be singular, or petitions, it says petitions, there's only one petition, so that should be singular. I'm not gonna worry about that. All right, that's it. So that was it. My only suggested corrections?
Need a motion.
I guess we do.
Unfortunately.
I'm sorry.
I make a motion regarding PLBOA 2024000105 to accept the recommended changes to the red line version as just stated.
Okay.
I will second that, John Kimura.
Okay, any discussion? Okay, we're voting on the motion to add the typographical corrections. Why don't we just all in favor? Say aye.
Aye.
Any opposed? All right, that's unanimous.
Well, I didn't hear Macy.
Yes.
Oh,
Okay, so then yes, it was unanimous.
okay, unanimous. Thank you, Macy. All right. So now we have the amended motion now, which is including all the red lines and those couple of typos. I'll entertain a
Discussion.
discussion. And hearing none, then we'll have the roll call vote on the final motion.
Okay, on the motion to adopt the findings of fact, conclusions of law, decision and order with the red line edits and the additional edits as presented by Chair. Board Member Scott Martin,
Yes.
Board Member John Kimura,
Yes.
Board Member Rachel Abel,
Aye.
Board Member Macy Wilson,
Yes.
and Chair Kathy Lewis.
Aye.
Chair, you have unanimous.
Thank you. All right, we did it. And thank you, everybody, for attending if you are here for that matter, those matters. Do you think we don't need a break, do we?
No, I'm just gonna,
Does anybody need a quick break or? Oh, I'm so sorry. My phone is.
I'll just note for the record that the board has adopted its form of the order. The staff will make the necessary corrections as stated. And it is from the point that Kathy signs that particular order that it will be in effect. Parties will receive an electronic copy as well as being uploaded into Epic. Thank you for your attention.
Thank you. There's one. All right, then we will then move on to new business. I'm sorry. We're going to call the only case today that we have left, and that is case number 3, Mark Kelberg. That is PL-BOA-2025-000124. This is an appeal of planning director's denial of petition for declaratory ruling, docket number 25-0001, dated July 18th, 2025, in response to Mark Kelberg's petition for declaratory ruling, numbered PL-INT-2025-010598, dated May 23rd, 2025, regarding the applicability of various sections of the Hawaii County subdivision and zoning codes, HCC chapters 23 and 25, to a subdivision approved in 2025, subdivision SUB-05-000064, location 32-977 Old Mamalahoa Highway, Ninole, Hawaii 96773, TMK, paren 3-2-002:034. Bethany, are there any public testifiers on this agenda item?
No public testifiers, Chair.
All right, thank you. All right, would I please, or can I please at this time get the names and appearances for the parties on this matter, starting with the appellant? Okay, will you say your name a little slower for me?
Yes, sorry, Deputy Corporation Counsel Sylvia Wan, to the parties, can you please, I apologize, one, you're going to be sharing a microphone.
I should have
and-
let you get settled first, I'm sorry.
And two, can you please make sure that it's on? It'll glow red. and then you can state your appearances. So you may need to be shifting this back and forth. I apologize. Thank you for
That was my fault.
being flexible with us.
I was a bad girl and didn't let you get
Clint Hamada for appellant petitioner Mark Kelberg.
Greg Hamada, okay. And for the planning department?
Good morning, Deputy Corporation Counsel Jean Campbell here on behalf of the Planning Department.
Okay, thank you. And, all right. Now, Bethany, has the appellant provided notice of the hearing to surrounding property owners according to Rule 8-11 paren D and proof of service?
Yes, Chair, that was filed April 22nd, 2026.
Thank you. All right, then we're going to move on to the hearing, and I'd like to ask both sides to know that we have read the record in this case and your briefing, which we appreciate. And with that in mind, you don't need to repeat what you've already provided us overly. Just know that we have reviewed your matter. If either side begins to present testimony or evidence that is not relevant, you may be interrupted and asked to move on. There is one legal issue before the board, whether the director's decision in question should be reversed or affirmed. And with that, let's begin. Now, the board will now hear any opening statements from the parties. And I ask if you please keep your statements to 10 minutes. When you're down to 2 minutes remaining, Sylvia, Ms. Wan will announce such, and we will start with the appellant.
Good morning, board members. We are here today to ask for the board's and the planning department's help. We are not here to fight about the subdivision's approval. We ask for guidance on this novel situation and how to move forward with this neighboring subdivision in light of the approval. Before I jump into the substance, I just want to provide some quick background on the case, just because it has been so lengthy. This case concerns a subdivision that was mistakenly approved by the planning department 20 years ago. Then Planning Director Ewan stated himself that the approval was a mistake because the subdivision resulted in more lots than previously determined. Now, I use the term mistake not to argue that the subdivision should be undone. It's simply to emphasize what a unique situation we are in. My client, Mr. Mark Kelberg, lives next to this subdivision. He was never given notice of the subdivision application as required by law and only by chance learned about it. He timely challenged the subdivision and fought its validity for the last 20 years. Ultimately, the Intermediate Court of Appeals and Hawaii Supreme Court declined to force the planning department to declare the subdivision invalid due to the passage of time and the fact that the lots have since been sold to new owners. As you can imagine, with a case that's been going on for 20 years, there's a myriad of other details and arguments that I've omitted, but that is the gist of the background and of Mr. Kelberg's previous litigation. Now, as to why the director's denial here should be remanded, the director states 3 reasons for the denial, and all 3 reasons fail. The director said the lot owners must be made parties to the petition. While we disagree that the lot owners have to be made parties to a non-adversarial declaratory procedure, they have since been joined, so we believe that reason should be deemed moot. The director's second and third reasons for his denial are based on a misinterpretation that Mr. Kelberg's petition is substantively a continuation of his prior litigation. This is plainly incorrect and what ultimately renders the denial erroneous and arbitrary and capricious. I want to make one thing very clear. Mr. Kelberg's petition is not trying to overturn the subdivision's approval. That was the subject of the last 20 years of litigation. That is not why we are here today. Instead, the petition asks for a forward-looking application of the zoning code to these subdivided lots if and when the lot owners attempt to develop the lots. This question has never been asked and has certainly never been answered by the department or the courts. As a foremost authority on the zoning code, it is the planning director's responsibility to answer this novel question, and this is the exact type of question that the declaratory ruling process is intended for. The subdivision's approval tells us one thing and the zoning code tells us the opposite, so which one rules the day? What can and can't these lot owners do with their properties moving forward when there's no way around the fact that their properties apparently do not conform to the zoning code. This is what I expect and hope is pretty novel in the county of Hawaii. I don't imagine that there are a lot of mistakenly approved subdivisions floating around in the county, and it's not a situation that landowners are accustomed to. Mr. Kelberg is not trying to divest any landowner of his or her property. The petition merely asks for the planning director's help in guiding everyone forward in light of this novel situation. Again, the planning director has the vested power to explain how the zoning code applies to this subdivision. We have a faulty subdivision that apparently does not need to be corrected, but that the zoning code says must be corrected to some degree if the lot owners want to use their property. Just by way of a quick example, as we pointed out in our pre-hearing brief, I'll try not to repeat myself, but all 7 lots are still zoned A20. A20 requires a minimum building site of 20 acres. Not a single subdivided lot meets that 20-acre minimum. Going even further, the minimum building site for any ag zone property is 5 acres, and there are 2 lots that are less than 3 acres. Another issue is the right-of-way for these lots. Prior to the subdivision, the singular large parcel could access State Highway 19. Right-of-way improvements and access were never addressed in the subdivision process, and we list several more examples of the urgency of Mr. Kelberg's petition on page 8 of the pre-hearing brief. We want to know what standards will govern these subdivided lots moving forward. Is it presumably the zoning code, as it does, every other landowner in the county of Hawaii, or do these lots somehow get a free pass to circumvent the zoning code by virtue of the mistaken subdivision? And if they do get to circumvent it, to what degree? I'd like to also point out that one of these lots appears to have somehow been granted a building permit by the planning department, which just further illustrates how important this question is. It's unclear what standards are governing these lots, and as a neighboring landowner, it is Mr. Kelberg's right to get those answers. And it is also the planning director's responsibility as the lead enforcer of the zoning code to provide those answers. In sum, the lot owners have been made parties to this petition, and the petition raises an entirely new question independent of the subdivision's past approval. So all 3 of the planning director's proffered reasonings for his denial fail, and these failures render his denial erroneous. Again, we are here today to ask for the director's guidance on these novel issues. Thank you.
Thank you.
It's a little awkward. Good morning, Chair Lewis and Board of Appeal members. I'm Deputy Corporation Counsel Jean Campbell, here representing the Planning Department. With me today is Deputy Director Michelle Ahn. I'm going to begin by correcting a couple of misstatements in the appellant's opening statement. There was no requirement at the time that this subdivision was approved for notice to the neighbors. The law has in fact since changed, but that was not an error at the time. Additionally, we'll just go with that for now. We'll go with that for now. Despite all the information before you, this case presents you the very simple question of whether the director's decision to deny the appellant's petition for a declaratory order was okay. This is not a referendum on a subdivision that was approved in 2005, which without question was messy, and we all wish it had gone differently. The only question before you today is whether the director complied with Planning Department Rule 3-1, which requires him to respond to the declaratory order petition within 60 days, and if he denies the petition, to include a reason for his denial. The director responded within 60 days and provided not 1, but 3 valid reasons for his denial. In order to overturn the director's decision, the appellant must prove, and you must also find, that the decision was illegal, clearly erroneous, or arbitrary and capricious, characterized by an abuse of discretion or a clearly unwarranted exercise of discretion. In this case, the director's decision clearly complied with Rule 3-1, and appellant has not proven otherwise. Appellant's displeasure with the 2005 subdivision approval, their frustration at the 20 years of unsuccessful disputes and litigation, and their simple disagreement with the director's 3 reasons for denial are not a finding of illegality, error, or abuse of discretion. Appellant has never identified a right that they have as a property owner to know what their next door neighbor is allowed to do with their property. This is a case of lawyers being able to modify their question in a way that makes it appear as if it's new and novel. But in fact, this is no different than every other subdivision that's ever been approved in the county of Hawaii, whether approved through the consolidation and re-subdivision process or approved through the standard subdivision process where the county is allowed to impose various requirements on that subdivision because they're creating new lots. In this case, the deputy director will explain to you the compliance with Rule 3-1, and we will have her explain to you the difference between those two different subdivision opportunities. That decision was made in 2005, and clearly the appeal period has long since passed. At this point, the only question is whether the petition, which did not allow an opportunity for the neighboring lot owners to participate by conflating this hearing, which does include an opportunity for the lot owners to participate, and the original petition, the appellant is telling you that they had the opportunity to participate, but they did not. So we ask that you affirm the director's decision because it was clearly legal and clearly in compliance with Rule 3-1. Thank you.
Okay. All right. Do you want to have a short rebuttal, or
Sorry, was that, Chair?
did you want to argue a short rebuttal?
Sure, yes.
How much
So-
time should we go? A couple minutes, maybe?
Yes.
Okay.
I'll just address a couple points. So, Corporation Counsel, listed off the standards that you need to review the denial under, whether the denial was erroneous, illegal, erroneous, arbitrary, and capricious. As she said, he stated 3 reasons. The first reason was that the lot owners need to be parties. You can tell by the case caption, they have since been joined as parties. Issue preclusion. The planning director believes that we are trying to undo, that's exactly what the last 20 years was about, undoing, revoking, invalidating, voiding the subdivision. You can look at our requested relief. That is not what we asked for. We are not trying to fight whether or not these meets and bounds have to be undone. We understand these lot owners bought property. We're not trying to divest them of their property. And the third reason was that, and is tied with the second issue of preclusion, that our petition is not in line with the intent of the declaratory ruling process. But that is incorrect because we are asking for a forward-looking application. Now, Corporation Counsel notes that there's not an absolute right to know what everyone next to you, what their rights are, what their property rights are. But I think you can ask any, zoning enforcer, what is the #1 way they get notice of any violation? A neighbor. We don't have people patrolling the streets, measuring heights, looking at setbacks. You have a neighbor who notices that maybe they're building something they shouldn't, and they file a complaint. All Mr. Kelberg is asking for is to know what can they do and can't they do. What I'd like the board to understand is when he purchased this property, when he started living in this property, there were 2 parcels next to him. You could expect 2 neighbors. There are now 7 parcels. That's not what his understanding of the subdivision would be. Obviously, he's discontent with that. Thank you.
Okay, thank you. You have a witness? Yeah. Do either parties have any more witnesses other than one? I'm just wondering if that's.
Well, yeah, because at this point, does the appellant have some evidence outside of the documentation they would like to submit as evidence in this particular hearing?
No.
Okay, I'm not sure what can you give me a really quick offer of proof of what she will testify about?
The deputy director can, excuse me, it's a little awkward. This one doesn't work well. The deputy director is here in place of the planning director because he had a conflict today.
Okay.
She is able to speak to the process that the planning department uses in complying with declaratory ruling petitions about what happened at the department and how the department approves subdivisions.
Okay, I don't know if that's relevant at this point. Feels. I mean, I hate to refuse you to have a witness, but I'm just not sure how that's going to illuminate. Do you feel that's pretty important for your argument, the testimony you want to present?
I guess the only point that I think that I would have concern that the board doesn't fully understand is the difference between two methods that you can get property subdivided in the county of Hawaii.
But we're not relitigating this.
And we're not relitigating that. So, but I do think that it goes to some degree to the allegation that this is not a relitigation of that point. So, but I would definitely offer that if the board doesn't feel that they think that that's something they need to know, that
Yeah.
we can stand.
Ah, gosh.
Deputy Corporation Counsel Sylvia Wan, at this point, given the arguments from the parties, I think it would behoove just to open up the floor to see if the board members have any questions of the parties and potentially of the one party's witness.
And if you do think you'll have any questions of the deputy director, we can swear her in.
That is correct.
Does anybody think that they will have questions for the deputy director? I do have a question, but it's for counsel for appellant. All right, then let's wait and see. I'm not going to absolutely deny you if you think there's something missing that you really want to get under. So I do want to ask you a question about the petition. All right, let's go way back to the time of the petition. And can you give me an example of a specific thing that was happening in those 7 lots or whatever, 7 subdivided lots that were raising concerns for your client and that he asked the director to answer a specific?
Yes, well, the number one and most pressing thing is, as I mentioned, there was an application for a building permit that appears to have been granted.
Say that again, please.
There was an application for a building permit by one of those subdivided lots that has since been granted. I have the permit number.
But did your declaratory ruling petition refer to that? Was it questioning what was going on with that?
No, that was
permit?
granted in May 24, 2025. We were unaware of it at the time of the original.
Okay.
petition.
Okay, and then as far as a building permit goes, I'm sorry, Deputy Corporation Counsel Sylvia Wan. My understanding is those are actually issued by the Department of Public Works. Isn't that correct?
Yes.
Okay.
I believe there's a little bit of interplay, but I think the final approval correct. You're correct.
Okay. So there would have been otherwise an opportunity to appeal that particular final decision from that department.
Yes.
Okay. And just so I'm absolutely clear on this, when the petition to the director was presented, the surrounding property owners were not joined.
Not in the original petition.
And not until when did they get joined?
I believe, I don't have the exact date, but it was during one of the pre-hearing conferences that we had for this appeal.
Ah, okay.
Okay, and then I'm going to step in again. This is Deputy Corporation Counsel Sylvia Wan. And speaking as the board's attorney, I'm just going to remind the board members of the board rules, which any petition that is filed with the Board of Appeals, automatic parties to that petition include the department in which their decision is being appealed, and the landowner, if the landowner is different than the appellant.
But that's for
So
us,
they-
right?
But that's just for the Board of Appeal.
Right.
So the Board of Appeals process and rules make those individuals automatic parties because the decisions that they are being questioned before the board affects the corresponding landowners. So please do not conflate the board's rules with the planning department's rules for declaratory orders.
May I just address one thing with that? I just want to go back to what I started with as far as with the declaratory ruling process. We're not asking to deprive them of any rights.
Say that again?
With the declaratory ruling process, we are not asking to deprive the lot owners of any rights. It should just be an interpretation of the law.
Right. I'm just all I was trying to get at is Was there something specific that you were asking the department to look at? But in general, it was a broad look at what
Yes, we listed off
overall,
many ordinances, and we're just
Okay.
saying,
All
how
right.
do these apply to these lots?
those are the only questions I have. Anybody else have any questions? At all? How do you feel about that now, Mrs. Campbell? Do you feel that you need your witness to go on at this point?
Actually, for what it's worth, board members, we're willing to stipulate that as far as procedure, timeliness, we don't object to any of that as far as the planning director's compliance with issuing his denial. It is purely the underlying substance and rationale.
Sure, yeah, okay. Yeah. You're okay. You're.
Oh, go ahead.
Yeah.
My only concern is that if we are actually talking about the substance of the reasons, that I want to ensure that the board understands that this is in fact a novel posing of the question in the petition that makes it appear to be a new and forward-looking question.
Right.
However, because what it does is it's actually questioning which procedure the county followed in subdividing this property. We would, if we were to find that all these new provisions apply, we are essentially redoing the subdivision approval from 2005. So if the
okay.
board is comfortable that they understand that properly, we don't need to call the planning director.
Okay.
And I will also note that some of the objections in the original petition were that the appellant objected to residential habitation, barking dogs and roosters on this property that might be next door to him, all of which are permitted uses in the ag district.
Well,
Okay, so Deputy Corporation Counsel
Yeah.
71, looking around, I will just note, it appears that each board member does not otherwise appear to be volunteering any other questions for the parties. And because it sounds like the parties' arguments is largely legal in nature, if any of the board members have any questions for me as your board counsel, relating to your roles, responsibilities, liabilities, the entire breadth of it, or want to ask me a legal question, I just want to remind the board that you do have the right to enter into an executive session to ask me any of those legal questions. If not, we are more than welcome to proceed. If the board members need a little more time to think, because this was a little bit of an anomaly of a hearing, we can take a short recess. So I'm just letting you guys know what your options are. It is up to the board as to the direction you'd like to go.
what, you want to recess? All right, we will call a short recess, 10-minute recess. Anybody else wants to confer with their client, they can do it now. You want to go into
If you guys would like to talk to me individually, we
I
can
don't
do that
feel
as
the
well.
need to, but go ahead.
Well, Rachel
Or-
seems like she's burning. so-
Yeah, right.
So here, let me go ahead and bring
Do
my
you-
notebook.
Do you want to
and I can
go
pretty
truly
around.
into executive session, into
Well,
another room?
let's see. If so,
All right.
we can go back on and go into executive session. If not, I'm more than okay to speak to each one of you
All right.
individually.
Let's do an executive session.
All right, we're going to do a full executive.
No, you want to pull it? Okay, well, then we need a motion.
Oh, okay.
Go ahead, John, make the motion.
You'll need a motion and 2/3 vote to approve.
Oh, okay.
John Kimura, I would like to make a motion that I'm sorry.
Okay, so, sorry, Chair, can you please bring us out of recess?
Okay, we're now out of recess, because, some of the board members would like to have a full executive session, so I would entertain a motion that we go into executive session.
Oh, yes, John Kimura, I would like to make a motion that we go into executive session.
Thank you.
I second.
Seconded, and all in favor, say aye.
One
Aye.
second,
Aye.
before we go,
Oh,
I have to put a little bit more
okay.
on the record as far as going into executive session.
Thank you.
As far as going into executive session, I just want to confirm with Board Member Kimura that it is for the purposes of consulting with the board's attorneys on questions and issues relating to the board's powers, duties, privileges, immunities, and liabilities.
Yes, exactly.
Thank you. Okay, now with that, board members can discuss that particular motion.
Yes, any discussion on the motion? All right, all in favor, please say aye.
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 Any opposed, say nay.
It appears that it was unanimous.
No, I don't know how we're gonna accommodate our,
We can,
Okay.
we'll just have we'll have to take a moment. We would ask everybody
Oh,
who is not a board member to please go ahead, or board staff, to please leave the room. We will be closing the doors. And in just a moment, we will need to take a little bit of transitionary moment so that our board staff can do the appropriate things on Zoom to get us into executive session.
yes, if you could close the door. All right. Take your time. There's no hurry. We're on.
Okay, so the middle of that.
So, because I don't have to put Macy in a, separate room,
Okay,
so I don't know.
like a breakout room?
Breakout.
Okay, she should be able to do that.
Separate from the two.
Yes. Yeah.
And
She should be able
to me,
to.
We're going to go back into calling order. Anybody can hear me out there?
Yep.
Mr. Kupchak, are you,
I can hear you fine, but
excellent? You
Mr.
can put your
Hamada,
camera on if you like.
Mr. Hamada is taking this one for us.
Oh, sure. Okay. Well, I didn't know if you wanted your camera on or not.
No, thank you.
I'll just note for the record that Mr. Clint Humata is present and approaching. And Deputy Corporation Counsel Sylvia, I'll just note as a summary for the record, the board entered into executive session and asked questions related to its duties and responsibilities, as well as powers related to making decisions for contested case hearings. Thank you.
Okay, we're back in session then. I think we're going to close the hearing portion of this and go into deliberations.
Do you want to do closings?
Oh, closing arguments?
Does the party even have additional closing arguments?
I mean, I would listen to a couple minutes each if you feel that you want to emphasize your top key points. Okay.
I'll keep it at
You've
3
been
sentences.
quite circumspect. I appreciate it.
I just want to emphasize what Corporation Counsel said at the very end. You know, she used the word novel. She said we framed it as if it's a novel situation because it is a novel situation. That's why we're really just here to ask for help. Thank you.
Thank you.
I'll offer that the novel question is a question about the substance and how the approval was approved in 2005. And the appeal period for that has long since passed. The director completely complied with Rule 3-1. And so we just ask that the board affirm the decision. Thank you.
All right. Thank you, counsel. All right. We've now closed the testimony and arguments, and we'll move into deliberations. At this point, I would entertain a motion regarding the matter before us in terms of affirming, reversing, remanding, whatever, with regard to the planning director's decision.
With respect to PLBOA 2025000124, I propose that we accept the planning director's denial of a petition for declaratory ruling.
Affirm. You're saying affirming? then?
Affirmative, yeah.
Okay.
I'm sorry.
All right, Scott.
25-001 dated July 18th, 2025.
Okay.
Is there a second?
Rachel Abel, I second that.
Thank you. All right, we're open for discussion now.
Scott, would you like to kick it off as to providing a basis for your motion?
Yeah, the underlying basis is, I really is rooted in, did the planning director adhere to 3-1? And my determination is that he did.
And all right, and so we're open for discussion now. All right, well,
Can I elicit maybe a little bit more as far as how the director complied with 3-1 and or the reasonings provided by the department? Is there any comment as to that? Go ahead.
go ahead, Scott.
I didn't hear anything to signify that it was a capricious finding. It was I'm at a loss for words.
Go ahead.
Rachel Abel, I would just say that he followed correct procedure, responded within time frame, and clearly stated the reasons for his denial, which supported the department's rule 3-1.
This is Chair Kathy Lewis. I would add that I'm very strongly convinced that the first reason stated, the failure to join the parties, is dispositive in my mind, because being joined later after the matter had gone forward, it's not the same as being joined in an appeal of the matter. None of the landowners were able to contribute anything to the petition for, or the request for the declaratory judgment. The director does have discretion, but I don't even think he exercised, I mean, I don't even think it was a discretionary thing. It was a sort of an open and shut case, that there was no joinder of people that would be, whose property rights stood to be affected. And so at the time he made that decision, and that's what we have to look at. We can't look at it after the fact, that he's joined them later. At the time, when he made his decision, that was not only not erroneous, I believe it was correct. Anybody else want to, is that convincing to you as well, or is there anything else that convinces you?
I just want to, because we've had 3 of the members speak, I just want to call out specifically, Macy, is there anything you'd like to add?
You know, I do think that the director did provide valid reasoning. And so I do think 3.1 was answered and done correctly. I don't think it was the answer they were looking for. I think that's where this is kind of going towards.
I'm going to also just add to the record something that really wasn't discussed, but as we know that a correct decision can be affirmed for different reasons. There was no specific issue going on. I haven't been provided with any evidence that one of the landowners was trying to do something that the planning director could apply the law to. And so it wasn't ripe for that question yet. And to me, that seems like it's just way too vague of questions that were presented to the director at the time. So I do think in that way, he did not abuse his discretion, but wisely applied his discretion.
And Mr. Kimura, do you have anything to add or?
I'm still kind of leery about the whole thing. But I am leaning towards doctor's approval.
Any further discussion, anybody? Okay, well, with that, I think we'll have a roll call vote on the motion.
Okay, on the motion to affirm the planning director's denial of petition for declaratory ruling dated July 18, 2025, Board Member Scott Martin,
Aye.
Board Member Rachel Abel,
Aye.
Board Member John Kimura,
Aye.
Board Member Macy Wilson,
Aye.
Chair Kathy Lewis.
Aye.
Chair, you have a unanimous decision.
All right, thank you, Bethany. And I want to thank you very much for your arguments and your presence here today. Thank you. And thank you to Mr. Kupchak as well for being here. Thank you.
So I'll just note for the record that at this point, the board has found to affirm the director's decision in this matter. As far as preparing of findings of fact and conclusions of law, as well as decision and order, the board typically requests that of the prevailing party. In this matter, that is the department. So we would ask, the board would ask that the department please provide a form of the order with the appropriate level of facts. In approximately 3 weeks, that due date would be July 2nd, 2026. And the opposite party, the appellant in this matter, may provide any objections to the form of that order by July 17th, 2026.
And then we do have a separate hearing to,
For that adoption, yeah. So the proposed will be put out. You can have your objections. And then as you had seen with our prior case, the board will then discuss and amend and or accept at that time.
we can't change our decision, but we can change the order.
We can change some wording. All right. Thank you so much. Thank you for your patience.
Thank you so much. All right, well, we'll go ahead now, moving on to the minutes. We are going to, excuse me, moving on to the approval of the May 15th, 2026 Board of Appeal hearing minutes. Oh, it says that the board staff is in need of additional time to complete the draft meeting. No wonder I didn't remember reading them. To complete the draft meeting minutes for May 15th. So that agenda item will be continued to the next board meeting. All right, well, that was easy. Finally, administrative matters. Ms. Wan, do you have a status report for us?
As far as the matters that are still the appeals of the Board of Appeals decisions, there hasn't been any significant updates since our last meeting. As far as other outstanding petitions, we do have a number of matters coming up shortly. Just to give a preview. If you give me a moment, please. I'll look at my handy dandy tracker. So presently, it appears that we have 3 cases set for July. These cases, of course, may be continued at any time. We have EO processing, which may likely continue. We have another case with Ms. Rohr. This is a new one. set for July 10th. I believe that one may have just been continued because it does appear that those parties are in settlement talks. So I believe that one was continued to September. And then we have a new Rose Hill case with Kaimu Cove is the landowner. We have that one currently scheduled for July 10th. A scheduling order has been issued, and so that one may be going forward in July. As far as August, we have Kismet LLC and Tradewind Productions. So those are just a little preview. Of course, those cases may end up continuing for any reason at the discretion of the chair and or request of the parties. So those are your previews. Otherwise, I'll let you know if anything else exciting happens and we have to deal with any other appeals that come back on us. Any questions? That concludes the update. Thank you.
Thank you. Staff, do you have any updates for us that?
Yeah, I do have an update. We have a new board member who will be joining us. Her name is Anna Liu, and she had previously served on the Banyan Drive Redevelopment Agency. And so Banyan Drive Redevelopment Agency. So we'll be working on scheduling her onboarding training, and then she'll be joining us. So that's awesome news.
And our other newer members have been trained already?
Yeah.
Yes.
Okay.
Yes. So I will just give one minor caveat to that. Her confirmation, knock on wood, cross the fingers, would be next week before council. So provided that goes well, she will be our newest member. Thank you.
Cool. We are adjourned.
Yeah, okay. It is 11:01. Thank you.
Thank you, everyone.